Okay, let's get right into this. Little groovy music to get us rolling, get us feeling good, feeling like we're actually supposed to be covering something special, which we are with a shitty printer. Look at that. Look at that print quality right there. Yeah, that is my personal printer, where we print off things that get a little sketchy right around the sides, right around the edges, if you will. I hope you're ready and excited for this amazing video. Let's get into it. Boom. So here's what we're going to be doing. We're going to be going into the Special Agent Handbook, Freedom of Information Act pull down. So we can use this one. It's had things pulled from it and blocked out, but we are going to be going through the details so that you actually get to know when the Social Security Administration, through their Office of Inspector General, through their CDI unit, investigators can access your house without a warrant. Now, they didn't always allow just complete unfettered access to a house without a warrant because there had to be something that occurred. Let's talk about what had to occur throughout this process. In order to get access to a house without a warrant, usually what's used is called a ruse. Now, pre-1950s, basically deception was very, very, it was mostly allowed. You could do, as a police officer, as a sheriff, you could pretty much do whatever you wanted to go ahead and get access to that house. There weren't a lot of cases that challenged it. It was one of those things where at the end of the day, they could lie, be disingenuous, and get access to your house, okay? 1950s, 60s, there was this shock the conscience test, right? If you lied to the person to get access to their house, would it shock the conscience that, they would feel coerced, that they allowed you into their forbidden area that you should not have been able to get into? And then we get into the post-Miranda rather. Basically that's where we have the Miranda rights being read. And, basically, it's a situation where it started to shape what they were allowed to lie about, what they were allowed to tell you in a ruse, how the police, how the law enforcement was allowed to schmooze you to get access to your house. And now basically it is still lawful today, okay? However, there are a bunch of restrictions. Now, the SSA has to follow specific ones, which I've pulled from the Special Agent Handbook of the Social Security Administration's SSA OIG. Now, basically, at the end of the day, they cannot fabricate evidence, documentation in most places that makes you believe in furtherance of the lie that they've created. So they're not really supposed to have documentation, whether it's a fabricated warrant, a fabricated report, a fabricated statement on a piece of paper. They're not allowed to do that. But once they use the ruse, and remember, sometimes you're supposed to be given a waiver as well, the bottom line is they can get access to your house without a warrant. So let's talk about that. Basically, at the end of the day, early 20th century, very beginning, right? So we're talking, early times, they allowed a lot of deception and undercover work, interrogatories. There was this idea that they were allowed to deceive you. They were allowed to basically lie to you to get entrance to your house, to your dwelling. And they didn't really go ahead and push back on that because a lot of people didn't sue because the cops would get in and then they would feel like they couldn't do anything about it because back then, basically 1910, 1920, 1930, even 1810, or 1890, 1880, stuff like that, people didn't have the expectation of being able to sue law enforcement. Okay. Then you get to the mid-century shift, and that was where you had Spano versus New York, 1959, and Lara versus Deno, 1954. That's where the deception of how they were allowed to lie to you to get access to your house started to get chiseled away and started to get limited. And they came up with this shocks the conscience test where basically, it would produce involuntary confessions. And they didn't like that. They said, whoa. We don't like this idea that the person is involuntarily giving these confessions by you deceiving them that they'd have to go a certain way. So if a ruse overbears a suspect's will or results in a false confession, it can violate due process at that point. So that's when things started to really change and create the now effect on us going towards them being able to access your house without a warrant, but being restricted in the shape of how they could use ruses to lie to you as law enforcement. Okay. Then we get to the next grouping. Basically, it's the Miranda rights. And after that, Miranda v. Arizona, everybody knows that one, 1966. Very important claim, right? So, the Miranda rights, everybody knows what those are. So it did not go ahead and get rid of the ruses. However, it did, usually like to request and have a waiver that was part of it. Okay. So we also had Frazier v. Cupp, 1969. So let's see. Police falsely told the suspect his cousin had confessed. Court allowed it, finding the confession voluntary. Oregon v. Mathiasen, 1977. Police falsely said fingerprints were found. Allowed since the suspect came voluntarily and wasn't under arrest. Now, if the police in that case had provided a document, right, in the modern day era that said, hey, we have these fingerprints on this piece of paper, which says, they were found. Here they are. This is the person. That would be illegal. That would be evidence that is poisonous fruit of the poisonous tree, meaning they're not allowed to go ahead and take it and eat it. It's not low-hanging fruit they're allowed to have. Now we get to the modern rule. Deception is still legal unless it crosses certain specific lines. So if there are essentially coercions or threats, they're not allowed to do it, right? Police officers are not allowed to coerce you specifically in addition with threats to go ahead and get access to your house. They're not allowed to say, there's some sort of disease or some sort of virus in your house. You have to get out immediately so we can go check it out because you will die if you don't do this. They're not allowed to say that. False legal promises, right? So you won't have a mean judge if you go ahead and do this, or you won't be charged if you confess right now, or if you let us in the house right now, we won't charge you. If you let us in the house right now, we won't go ahead and seek the penalty of this against you. Cool. Then there's, of course, fabricated evidence introducing basically, could be at any point for the most part, because the courts are really becoming aggressive with this. If they're making some sort of document that says, hey, at the end of the day, bottom line, this is the truth and it's on this document and they present it to you, then that's just not allowed. They do not want that. And then, of course, any major deception, lying about having a warrant, then not having it, lying about, something where they have a legal right to go and do it when they don't, that true leading of deception, the illegal searches that come from them claiming something legal that you might not know about. Those are the things that ultimately, at the end of the day, will equate to a situation where they will not be allowed to use the evidence that they collected when going into your house. And I want to point out specifically what I mean by that. So a lot of you guys think the real punishment that will happen to the police is that they'll be fired and terminated and they'll be laughed out of town and how dare they and yada, 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 yada. That's not what happens. They're just basically, for the most part, not allowed to use the evidence as a part of the trial. I mean, sure, the cop might get a slap on the wrist, but they won't be able to use the evidence against you or somebody else as a part of the trial. Now, let's get to their specific Special Agent Handbook on behalf of the SSA. I have legally obtained a copy of this. Let's read into it real quick. Okay. Execution of search warrants. So we're going to first talk about when they can go ahead and do the execution of search warrants. It's under section 013.070. Okay, here we go. Announcement. Title 18, United States Code section 3109 requires special agents to announce their identity, authority, and purpose before entry to execute a search warrant. So if they're going to bring a warrant, they've got to go ahead and announce their identity, authority, and purpose before basically getting entry to execute a search warrant. Okay, the announcement need not be lengthy or elaborate. It must, however, be conveyed in such a manner as to make it unmistakable what is taking place to the person to whom the announcement is made. Following announcement of identity, authority, and purpose, the SA, the special agent, should demand entry. That's if they have a warrant. When several special agents participate in the execution of a search warrant, one should be designated to make the announcement, right? And that's how they usually do it. You always see it on TV that way, etc. Exceptions to the announcement requirement. Let's go through this real quick, okay? When the special agents are aware of facts that justify the execution of a search warrant without announcing their presence, such as information must be articulated to the magistrate judge And the special agents must include in the affidavit those particular circumstances which would support the no-knock situation. Accordingly, the announcement requirement need not be complied with under the following circumstances. So just to clarify, this is when a sheriff, a police officer, a social security investigator investigating a case, interacting with somebody they believe has committed fraud, somebody who's basically gone down the wrong path. This is where they're allowed to not have to knock, and they can just enter the house. While they do have a warrant, they don't have to show it to you. Okay, here we go. Where the special agents executing the warrant, executing the warrant, reasonably believe the announcement will place themselves or other persons within the premises in imminent peril and bodily harm. So if they know that you own firearms, if they know that you have a big dog that you're going to let out of a room, if they know that you can set up, booby traps or something like that, if they know that you're going to some way put them in, potential serious bodily harm, they don't have to show you the warrant. They can just access the house. So just to kind of keep that in mind, that's a unique situation where they can get entry, they can go in, and they don't have to go ahead and announce who they are, what their authority is, and why they're there. Okay. Next one, where persons within the place to be searched already know of the special agent's identity, authority, and purpose. So this is a tricky one, because if it's a situation where they're arriving and they're like trying to get in, and the person that they're trying to serve already knows their identity, their authority, and purpose. Now, sometimes movies show this, where it'll be like somebody standing outside the house with a bunch of, sheriffs and police and law enforcement and federal agents. And they're like, all right, we're going to go in, blah, blah, blah. Obviously, the person knows who's there, what's going on, and why this is happening. Okay. Next one, when the special agent has reason to believe that the evidence sought under the warrant is in the process of destruction or removal. So here's one that we see on TV sometimes, and that's where the special agent will break down the door, run in, run to the toilet, and capture video coverage of essentially like, narcotics being, flushed down the toilet. Or basically like where somebody is, claiming that they're this, and that. And then all of a sudden, what will happen is they know that they're going to destroy the evidence. They're going to ruin the evidence. They're going to get rid of the evidence. So they have to break through the door and go ahead and save the day. All right, that's your John Wayne stuff. Entry. The manner of entry to conduct the search will depend upon the response of the persons against whom the search is directed. Now, remember, we're going to go through entry, and then we're going to go through entry by ruse, trickery, or deception. And that's the part where they don't need specifically a warrant to access your house. Here we go. Entry. If the person complies with the entry demand, the agents may enter immediately and conduct the search. If the person refuses to comply, an immediate forcible entry should be made. So in other words, if they've got a warrant and you're like, hey, you shouldn't be able to get access to my house, I don't like you. And they're like, well, we've got a warrant signed by a judge, we're coming in. You say, no way, Jose. They will break down the door, they will get entry into the house, and they will do their search. Okay. The degree of force used must be reasonable. That is, it must be minimally sufficient to promptly and safely gain access. That level of force would equate to forcing open a door or window. So in other words, just to kind of help you understand, they can't drive a tank through your house to get entrance, but they can destroy the window and the door to get access. Devices such as pry bars, axes, and battering rams may be used if necessary to make immediate entry. If the person to whom the announcement is made remains silent or responds ambiguously to the entry demand, agents must wait a reasonable time before making a forcible entry. There's no set minimum time. A reasonable time depends on the facts of the case, taking into account such factors as the size of the location, the destructible nature of the evidence, the time of the day, and the physical condition of the occupant, which is important for disabled people here and elderly people on retirement benefits. A reasonable time also may depend on the object of the search. What may be reasonable with respect to stolen computers may not be reasonable when records on flash paper or water-soluble paper are sought. So in other words, if the person could potentially destroy whatever evidence they're searching for. So let's say it's a person on disability benefits and they're, uploading stuff to a computer and they're sharing lots of files of, government data, or if they're sharing lots of files of things that they shouldn't be sharing or things that they don't own that are digital, and the government's not happy about it, they're real pissed about it, then in that instance, if it's on a flash drive and they got to get to that flash drive, they're going to get to that flash drive. Okay. Next one. If during the announcement procedure, the agents have reason to believe the evidence sought is in the process of destruction, an immediate entry may be made. That's when they John Wayne it. They just go in, they basically hyper search the area. That's where they're doing that, like checking doors, checking ceilings, all that jazz. Agents are under no obligation to argue or negotiate with a person whose property is to be searched, nor should they display credentials through peepholes, slide a copy of the warrant under the door, otherwise delay the execution of the warrant beyond the procedure described above. So in other words, just to kind of clarify for people, when specifically they have for essentially, they have a warrant to go ahead and search it, and we're going to cover when they don't need a warrant next. When they have a warrant, they're not there to have a conversation with you to get entry to search your place. They are there to get you to agree to it or not agree to it. But either way, you're getting put in the corner. And then they're going to go do their search and do their thing and figure out whatever they want to get whatever they want. Okay. So now here's part D. Specifically, entry by ruse, trickery, or deception. Okay. And for those who are just joining us, I have a treat for you. We're specifically going into essentially the Special Agent Handbook, which I legally obtained for the U.S. Office of the Inspector General, specifically for the Social Security Administration, Office of the Inspector General, Office of the Investigations, Baltimore, Maryland, 21235-6401 handbook. Okay, so I'm giving you guys stuff that I legally have obtained a copy to. And keep in mind, you know what I mean? Things are blocked. It's a B7E, restriction. So just keep in mind. All right. And that's the thing. Literally, the section we're about to read, a major portion of it has been blacked out. So remember, not everything can be shared with you, obviously. All right. It's not that we don't love you. It's just you're not supposed to know everything, and the government, does that. All right. Entry by ruse, trickery, or deception. Unannounced entry to a constitutionally protected premises obtained by fraud, deceit, or misrepresentations to execute a search warrant does not violate Title 18 U.S.C. Section 3109. However, the entry must be effected without any force whatsoever. So let me read that to you again so you understand the full breadth, the full existence, the full holy crappery of that sentence. Unannounced entry to a constitutionally protected premises where you live, your apartment, your house, obtained by fraud, deceit, or misrepresentation to execute a search warrant, not violate Title 18 U.S.C. Section 3109. Okay, that's to execute a search warrant. However, entry must be effected without any force whatsoever. So what they're saying is, if they want to execute a search warrant and they can get access using fraud, deceit, and misrepresentation, they're allowed to do it. They're allowed to do it. So if they're allowed to lie to you, right, and get access, they can execute a search warrant. However, they cannot use any force whatsoever. So if they start getting frisky and spicy and pushy, right, then they're not allowed to use the traditional fraud, deceit, and misrepresentation methodology within law enforcement. Nevertheless, such a practice is generally unnecessary and should be avoided unless extraordinary circumstances are present. The government then goes on to block what is an extraordinary circumstance, because you're not allowed to know that. That's the reality. You're not allowed to know to what level extraordinary is defined as. Okay. Resistance or interference. Okay. Title 18 U.S.C. Section 2231 makes it a felony to forcibly assault, resist, oppose, prevent, impede, intimidate, or interfere with any special agent authorized to serve or to execute search warrants or to make searches and seizure while engaging in the performance of his or her duties. As such, a person may not legally obstruct the execution of a warrant and can be immediately arrested for doing so. So let me put it to you this way. When they have a search warrant, And how do you know if they're real law enforcement? That's a problem, because you don't know, and they have like an unfettered existence to basically push you aside. Because if you're like, you cannot enter my house, and they're like, we have a search warrant. What I mean? They can use force to some degree. They really can, and it's quite a lot of force. It's a surprising amount of force. Now, if they don't have a search warrant and they're going up to your house, they can go ahead and lie to you, and they can go ahead and talk with you, tell you a story about something. Oh, we heard that in the neighborhood there was this going on. Have you heard anything about it? Do you have a pen that I can borrow? Oh yeah, just come on in. I'll give you a pen. That is totally allowable. No, not allowed to use force. They can lie to you so long as they don't use paperwork to continue to push the identity of the objective of their lie. So they're not allowed to take a document with a lie on it and say, oh, yeah, this is done. Now, they can take documents, right, that basically are true, right? And they can show you, yeah, I don't know if you saw this in the paper yesterday. I don't know if you saw this police report that occurred, da, da, da. But if there is something, right, that is fraudulent on the documentation, then they're not allowed to go ahead and bring that forward, because that would mean they are stepping over the boundary of not using a search warrant. Okay. A violation may be shown even though the person resisting does not use force or violence. So basically, if they ever come to your door and they're like, hey, we think that you might be fraudulently claiming disability benefits. Hey, we think you might be fraudulently taking the retirement benefits of somebody. If they come to the door and you obstruct them, let me read it to you again real quick. This is important to know. So if you obstruct them from basically, by forcibly assaulting, resisting, opposing, preventing, impeding, intimidating, or interfering with special agent, then pretty much, they'll put you in the corner, they'll take you to jail. A violation may be shown even though the person resisting does not use force or violence. So they can, even if you don't use force or violence on them, they can still take you. Any decision to make such an arrest, as well as an announcement of the arrest to the arrestee, can be made by the special agent or by the federal, state, or local law enforcement officer also participating in the operation. Now, some of you are probably wondering at this point, why is the SSA with capacity to arrest people? And technically, the thing is this: the SSA doesn't really set out to arrest people. They set out to investigate people, but they hire local police and sheriffs who can arrest people. And so as a result, they train them as part of their Special Agent Handbook to, with capacity, go and basically arrest people if an arrest needs to be made. Okay. So can the SSA have employees that work for the Office of Inspector General under the CDI units actually arrest you? Yes. Offensive or abusive language shall not be interpreted as resistance or opposition. So if you tell them to go bleep off, that doesn't count. Arrest under this statute requires proof that some overt act was performed in an effort to defeat the purpose of the warrant. Threats with a weapon are examples of such overt acts. So if you pick up a belt, if you pick up a big stick, if you pick up a giant ruler and you get real slappy with it, then yeah, that's a problem for you. Okay, next one. Destruction or removal of evidence sought under warrant is a separate criminal violation, Title 18 U.S.C. Section 2232, as in any forcible attempt to rescue property already seized by the searching special agent. So if the special agent takes the evidence, right, and they've got it in their possession, and they're walking towards the door, and then you grab it from them, that is, again, a new crime, and you go to jail for that. You can go to jail. All right, so now, scope of search. After having made entry, special agents should take whatever steps are reasonably necessary to protect themselves. Special agents should control the movements of persons found inside the premises and may frisk such persons for weapons based upon a reasonable suspicion that they may be armed. Now, they're not going to show up without knowing what licenses you have for what firearms. So they're not going to show up without knowing that. They're going to know people who likely live in the house. They're going to know whether or not there's likely firearms present. So, if they're going to some California home and they're very, very hyper liberal, they're one of those, individuals that lives by the namaste and like praises the sun god and things like that. And, everything's natural and they probably eat quite well. They're probably not too worried about firearms, right? That this probably, the product. But if they go to somebody in Texas, right, who's got a nice hat and has great boots It has a nice truck, high country, right? One of those trucks. Yeah. Okay. Lone Star State, one of those yada yadas. All right. So, you get one of those types, a nice Chevy, nice Dodge, a Ford that's not going to fall apart, man. My Ford breaks all the time, all the damn time. Ugh, all the time. My Toyota rarely breaks. It's like I'm stuck in this middle zone. Like the Toyota rarely breaks, the Ford breaks all the time. I'm getting hit in the middle. You know what I mean? I'm getting like the average amount of burn. All right. With that said, let's keep reading. Searches of persons found within the premises for evidence described in the warrant are not permissible unless such persons are particularly described in the warrant. Okay. So basically, if you're in the area where a warrant says, hey, just to be clear, like the evidence that they're searching for, which it could be anything. It could be that you're, selling drugs on the side while getting disability benefits. It could be, a picture album of all the images where you go overseas, even though you're on disability benefits and work for somebody else. If somebody else is in the room, they can't search that person unless the warrant specifically goes into detail about it. If the items sought could possibly be concealed and on individuals thought to be in the premises, such persons should be named in the warrant. So in other words, when they get a warrant, they're going to get a bunch of people listed on it so that they know all the different individuals that could potentially exist pertaining to this, that at the end of the day, just to be clear, could have it on their body. So when they do these search warrants, they're going to be like, okay, we're going to go search this guy's house. But this person, this person, this person, this person, this person who have been seen there, lived there, we're listing them as well as potential assistive individuals who might be holding the evidence. Cool. The search may extend to all places within the premises where the evidence or the person sought could logically be concealed. The warrant will typically authorize a search of all containers and personal property found on the premises described, including the resident subject's automobiles found on the curtilage, it's the area around the home, that could conceal the items sought. So when they show up, if they don't find it, they're doing a deep scrub. They're going to scrub. They're going to go through the cars. They're going to go through the trash. They're going to go through little compartments that they find outside. They're going to flip stuff over. They're going to look at that weird backpack that's sitting over in the corner that doesn't look like anybody wants it to be noticed. All that stuff. Note, if the automobile is parked on the street, it cannot be searched under the authority of the premises warrant. Okay? So in other words, you park it in the curtilage right by the house, they're going to search it. They're looking for it, they're going to search it. If it's parked on the street, it's not in the warrant, which to be fair, like they're going to list a bunch of vehicles too. They're going to list the ones you own, the other ones these other people own, blah, blah, blah. If it's on the street, it's not in the warrant, they can't search it. The scope of the search is directly related to and is controlled by the objective of the search. Agents are under no obligation to begin or end the search at any particular place within the premises. So they don't have to start in the kitchen and end over in the whatever area. Okay. Let's talk about this. Duration of the search. Okay. And I know we're doing a lot of search warrant stuff because I think it's important. Because here's the thing. We did a case back in the day where the person did not use a search warrant. And he schmoozied on up to the homeowner. And he got access to her home. And the idea was he wanted to show and prove that she wasn't disabled. Or at least he was there to execute the doing the actions that would equate to that, right? And so what happened was he ended up getting access to the home. One of his cameras failed. One of them didn't fail. But he was able to capture footage of her wheelchair with blankets on top and dusty arms, right? And he's able to capture other footage showing that she wasn't really as disabled as she claimed. And as a result of that, she was like, hey, what the hell? And they went through a whole legal case as a result. But the bottom line is, using a ruse, he lied to her about things going on in the neighborhood. He got access to her home. He collected information to show that she wasn't as severely disabled as she claims she was, where she said, oh, I have to use the wheelchair all the time. And then as a result of that, right, they ended up in a situation where she did a lawsuit and the whole thing, became a whole thing. All right. Duration of the search. A search under warrant must be terminated when the evidence described in the warrant has been found and seized. Now, when they access your house without a warrant, right, because they did it through a ruse, right? They're trying to gather as much information as possible. So it's not like where you have a warrant and you're looking for a particular item. They're trying to get, their camera to capture as much as they can in as many rooms as they can. Where one of the several items described in the warrant has been discovered, the search may continue for other evidence. If no evidence is found or when the last item specified in the warrant is found, the search must end and the special agent must leave the premises. The authority of the warrant to intrude on the individual's reasonable expectation of privacy extends only as long as is reasonably necessary to search. Special agents who remain on the premises for an unreasonable period become trespassers, and any subsequent evidence obtained may be suppressed. So what they're saying is, if they find the thing in the warrant, if they're telling you we're here to search and we have a warrant, find out what is in the warrant. And once they find that thing, tell them to leave. Because at that point, if they're staying beyond that, then they are a trespasser in your house. And any evidence they find beyond that, they're not allowed to use. It must be suppressed. Intensity of search. Now, here's kind of an interesting one. Here's what they're allowed to do once they're inside your house. Now, remember, if they access your house without a warrant via a ruse, then what happens is they're going to be polite. They're not going to destroy your house. They're not going to rip stuff up. They're not going to flip stuff over. They're not going to go through your underwear drawer. But intensity of search, section H, right here. Right here. But the search warrant is not a license to destroy property or to harass individuals. It will permit, however, under certain circumstances, a highly intensive search that may disrupt the damaged property. Thus, a floor may be pulled up, or a wall torn down, or a garden dug up, where special agents have a reasonable belief that the evidence sought under the warrant has been concealed in such a place. Such actions should be taken only under the most persuasive of circumstances. Which is kind of like holy cannoli, because it's like, imagine these people come in and they're like hammering down the wall in between you and the bedroom next to you. It's just like, now people do hide stuff in walls. That's absolutely there. Plain view doctrine, where special agents are lawfully present on the premises as during the execution of a warrant, or, if they get invited through a ruse, and they observe evidence or contraband in plain view, such evidence or contraband may be seized, even though it is not described in the warrant and not relevant to the offense under the investigation. In order to validate the seizure, a special agent must have probable cause to believe that what is observed in plain sight is evidentiary, and the discovery must be inadvertent or unanticipated. So if they come upon your stash, right, and they didn't expect a stash, then they can go ahead and seize it. The plain view doctrine will not permit the seizure of evidence from a place within the premises where the special agent has no right to be. Even though the agent is lawfully on the premises, the three necessary elements for a lawful plain view seizure are the following. These are important to know. Special agents under the SSA must be lawfully present. Simply stated, the special agents must be legally justified in being where they are at the time the plain view observation is made. Discovery must be inadvertent, right? They weren't expecting to find it. They just came upon it, happen. Items must be of an immediately apparent incriminating nature. Like, you got to look at it and be like, oh, that's a pipe. You know what I mean? Oh, that's what that is. Special agents making the seizure must have probable cause to believe, without further investigation, that the item in plain view is evidence. All right. Now, with that said, we're not going to go through inventory. Leaving a copy of a warrant, we can cover that another time. Damage to property, we will cover in another video. Here's the deal. Before I go through the summary of what you should keep in mind and learn from this whole thing, it is that basically law enforcement exists within the capacity of the Social Security Administration with an office in nearly every state, and then they have hubs both in and outside of the country. Before we go into the summary, please remember to like and subscribe. Hit that like button. Also, if you need Medicare, please feel free to go ahead and call these guys for a free tune-up. They basically do a free phone call, It's a free experience for you. They are Medicare brokers that basically work with essentially the different health insurance groups to set you up for usually a money saving, that's better for you program under Medicare. Your specific medications, your specific upcoming surgeries, your specific needs for doctors, your specific needs for specialists. Give them a call. They're right here, 339-226-6287. AskChapter.org/disability. Obviously, why disability? Because I'm the most viewed and subscribed to and clicked on disability attorney in America. Now, with that said, I'll hold it up for a little bit more. That way you have the number. We're going to hang a sign right behind me in the not too distant future. Okay, what's the next thing you need to know? In summary, just so you understand what we've covered, there are two main ways that special agents acting on behalf of the SSA can access your home. One is with a warrant, one is without a warrant. The warrant one is simple. You know how it works. A judge stamps it. They put a bunch of information in it. They get access to your house. They go grab the thing that they're looking for. Cool. The other option is without a warrant, which is using a ruse. Now, they've shaped the laws to allow a very lawlessness in the very beginning to now a more specific, can't shock the conscience, can't be coerced, can't be this, can't be that, can't be fear for their life. They put all these restrictions on it, but now they are still allowed under the SSA, under the OIG, under the CDI unit, investigators. They are allowed to come up to you, whether in full police attire or not, whether badge is present or not, to go ahead and interact with you and talk about what their objectives are, even if their objectives are a lie. They may come up to you and say, hey, did you know that somebody last night saw a potential murder? Did you know that that person ran down this street and we're trying to find who that was? Can you tell me, do you have any video footage of this occasion? Because I see you have a camera there. Can you show me on your computer the system so I can see what videos are there? Oh, sure. Come on in. Da, 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 da. That's a problem, because if they do that, they're going to get in. They didn't show you any documentation, which would cause you to believe that, this false documentation provided, where they create a document, that's a lie. They didn't show you any of that stuff. They just told you it. You gave them access, and now they can collect the information you want. Now, some of you, right, are the disabled person that which you claim you are. Some of you, not so much. And let's call it like it is. We all know what happens, right? You get on disability benefits, you stop working. Things sometimes improve. Sometimes they get worse. Sometimes they improve. And some of you have impairments that don't really look like you have impairments. So it's a tricky situation, because then you've got a situation where, it appears to be, it looks like it might be a situation where you might not be the disabled person that what you claim you are. So if you're smiling and interacting with a police officer, but you claim you have really bad anxiety, interpersonal, connection difficulties, right? Then maybe that won't come out when they're interacting with you. So as a result, please remember, if somebody shows up and they're looking to get access to your house and they're looking to schmooze you and get access and get in there and talk to you and see what's going on, and you don't really know them, then that could be a problem. Also remember, if your neighbor is trying to go ahead and find things out because maybe they had an interview with one of these OIG agents and they get access to your house to collect more information and then give the agent a call, that's something to keep in mind too. If you're disabled, you kind of want to protect what your dwelling looks like on the inside, because if you were to look around your room, you might find things that make it seem like you're not as disabled as you claim you are. For example, having a barbell or some sort of weight for lifting in the corner. Or maybe you have some sort of workout device, like a stair climber, like a bike, like a running machine. They got all kinds now. You got ones that rotate, the classic treadmill, all that stuff. Maybe you have a giant collection of really tiny hand-painted objects, and yet you claim before the SSA that you do not have the dexterity to use your hands to do general gross gripping or fine manipulative functions like typing on a keyboard or painting. So, as a result, you want to protect the interior of your house, because if they have a warrant, they're going to come in. If they're able to schmooze you to get access to it, they're going to come in. And the thing you have to keep in mind is the laws are pretty set at this point. We've gone through essentially what they were going to set up for what was allowed to get in. You have to understand also, they do not send out the police officer. They do not send out the sheriff that is bad at connecting with people. They send out the guy or the girl that seems really innocent and kind and nice and wonderful. And when they do that, it creates a situation where you believe, hey, maybe this person isn't law enforcement. And I showed you the video from that other video where the person was getting arrested. A pretty young female walked up to the door and said, hey, I'm really sorry. I'm pretty sure I hit your car with my car. I feel really bad. He goes, which car? The one in the driveway. I feel really bad. Do you want to take a look at it? Do you want to exchange insurance? And he's seeing this beautiful little, female going da 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 da. And he goes, okay, let me go take a look at it. He goes outside. He's arrested. Okay. There's different ways to do a ruse. There's ruses to get you out of the house. There's ruses to get into the house. There's ruses to basically put you in a specific spot of the house. All those things. Please keep this in mind. All right, everybody. Please remember to like and subscribe. Head over to Google. Click on Disability Resolution Law Firm or Disability Resolution Florida. Throw some stars up there if you like on the business profile page. We always appreciate those. With that said, I go live on Mondays and Thursdays. I didn't go live yesterday because I was working too late. I just didn't have time. It's going to be too late for me to go live tonight, so it'll probably have to be like tomorrow or the next day. It's just one of those things where I'm working really late, and it is what it is. I will do one extra video after this, and please keep in mind if you want a private session with me for 30 minutes or an hour, mini contract is below. And also remember, if you have Medicare, give them a call. Let them figure out if you've got a really great plan. Let them go through all the policies that they have on their side. They do, and it's been proven over at Chapter, have more access to more policies than any other provider because they're like a big, mega nationwide group. So the point is, let them do their job. Let them go ahead and get you a really great deal to tune up your Medicare. I will catch you a little bit later. You have a wonderful, wonderful day, and we will rock and roll from there. And I will see you at the next video in about 5 to 10 minutes. Thank you so much, and my apologies for being late to this video. I was finishing up a brief. Catch you soon, and we'll go from there. Thanks so much. Bye-bye, everybody.